So is it good to go? Am I
Yes,
audible to you people? Great.
yes, ma'am.
All right. So next example for the bailment is A bails 100 of mark with a particular mark to B. So he's gonna bail some goods. Or he's gonna bail 100 bales of cotton which has got a particular mark, and he bails such goods to B. B, without his consent, mixes 100 bales with other bales of his own. So like I told you before, he is not supposed to mix the bale goods with his own goods. He must take reasonable care to ensure that the goods bale do not mix with his own goods. So any kind of damage which occurs because of that, he has the cost be borne by the person who has goods with his own goods. Correct? So what happens is A is entitled to have his 100 bales returned, and B is bound to bear all the expenses incurred in separation of bales and any other incidental damage, right? So when he mix bales of 100 bales of cotton marked with which has been marked with a particular mark, he has to now separate the bales from his own bales. If he does, when he does so, he might come across some expenses, right? That has to be borne by Mr. B. Or in case of any incidental damage to it, it has to be correct. So to return the bail goods timely, it is a duty of the bailee to return the goods bailed to him as per the directions of the bailee after accomplishment of the intended purpose without the demand from the bailer. Isn't it? If there is any particular time, if the purpose is being done, if the purpose is accomplished. So when I bail my bike to an authorized dealer to service my bike, when the bike servicing is done, he has to return the bike to me on timely, even without the demand from the dealer. So we'll talk about the termination of a bailment. When a contract of bailment is terminated or comes to an end. On the expiry of the period, when the bailment is for a specific period, it terminates on its expiry, isn't it? So if it is only if a contract is entered into between two persons for a bailment of goods only for a specific period, the contract expires. A lends his three-wheeler auto to his friend B or for 3 months hire on payment of monthly hire charges. On the expiry of 3 months, the bailment contract stands discharged, isn't it? It comes within stipulated time. Once a stipulated time comes to an end, the bailment contract stands discharged on achievement of the object. So when I say on achievement of the object, you give your bike to the servicing company to get a service and repair done. Once the achievement, what is the achievement of the object? That is, the bike has to be serviced, right? So on achievement of the object, it comes to an end. When the bailment is for a specific purpose, it stands terminated on the accomplishment of the purpose. So when your bike is being serviced by the auto dealer and you're taking delivery of it, it stands the achievement. The object of entering into a bailment contract is achieved, right? Your purpose is done. Let's deliver his motorcycle to T on completion of repair work by T. The bailment stand discharged. Correct. Third point: destruction of the subject matter of goods. So what happens? Bailment stand discharged of the subject matter by reasons of change in nature, it becomes incapable of use or for the purpose of the bailment. So what happens when your bike is broken or there is no way you can service your bike? So what is the subject matter of the bailment contract? It is the bike. So when bike itself is destructed, it may be because of a natural cause also, right? So what happens when the subject matter of goods to the bailment contract is destructed? Then the bailment stands discharged. It becomes terminated. Death of a bailee or a bailer. So if you lend your bike to Mr. B for 3 days, and what happens? The other person dies. Then the bailment stands discharged, right? Stands discharged by the death of either of the party, bailer or bailee. So that which is bailment can be terminated any time subject to condition laid down in section 159 of the contract. So suits by bailee or bailee against wrongdoers. right to interplead. If a person other than the bailer claims the goods bail, he may apply to the courts to deliver of the goods bail and to decide the title of the goods, isn't it? If a person other than the bailer claims the goods bail, so let's say a person, he gives his bike for repair, claiming that it is his bike, but actually it is a bike of another person. So he may apply the courts to stop delivery of the goods bail, right? So a person who has stolen, Mr. A has stolen Mr. B's bike and going to see, telling him that I'm going to give my bike for service. After 3 days, I'm going to collect it. Now the person B comes to know that A has given the stolen bike to the bailee. Now he can apply in courts to claim that the goods should not be delivered to Mr. A because he has stolen my bike, and the court has to decide the title of the goods based on the evidences. Sued by bailer or bailee against a wrongdoer. So before that, am I audible? Am I clear?
Clear.
Okay, fine. So sued by bailer or bailee against the wrongdoer. If a third party wrongfully deprives the bailee the use of goods bailed or does them any injury, the bailee is entitled to use all such remedies as the owner of the good master might have used. Either the bailee or bailiff may file a suit against the third party in this case. So, if a third party wrongfully deprives a bailee of the use of the goods bailed, so you as a bailer give your bike to the auto repair store who's a bailee, and a third party, what he does, he breaks everything in that auto repair shop and he does injury to all the goods over there, bailed goods. So the bailee is entitled to use all such remedies as the owner of the goods might have used, right? So he has he has all the rights. So though you have given the possession of your bike to the bailee, right? Now he can use all such remedies as it would be available for the owner of the goods. So either the bailee or the bailee may file a suit against the third party. All right. Even a bailee can, on your behalf, file a suit against the third party for any kind of damages that may have been caused to the goods. Apportionment of relief or compensation obtained by such suits. Whatever is obtained. Okay, so you file a suit and you claim damages for the damage caused by third party. So whatever is obtained by way of compensation, any such suits as between the bailer and bailee be dealt with according to their interest. So apportionment of relief or compensation obtained by such suits can be dealt along with their respective interest. So what is bailee's particular lien? What exactly the word lien means? This is dealt under section 170. Lien means right of the person to retain the possession of some goods belonging to another until claim of the other person in possession is satisfied. So let us look into this example. A delivers a rough diamond to B, a jeweler, to be cut and polished, which is accordingly done. B is entitled to retain the stone till he is paid for services he rendered, isn't it? So you go to a shop. So what happens is let us put it in a very simple way. You go to a auto repair shop, you give your bike for servicing and repair, and he does the service. Now he will return back your bike only when you pay him the service charge, isn't it? If you don't pay him service charge, he has all rights to retain your bike until you pay him the amount for the services done to your bike. Pledge, honor, pony. So could one of you tell me the meaning of pledge? You would have definitely come across this word pledge, right? So can anyone tell me what exactly does the pledging of goods mean? You pledge your jewels, correct? Exactly. So that's what
security.
Yes, exactly. So the bailment of goods or security for payment of a debt or performance of a promise is called pledge. Okay. So what you do, you go to a bank and you ask them for a house loan, right? Now bank says that you have to give pledge one of your property. Then we will give you some amount. So the what you're doing, you're pledging your another property to get some amount from the bank, right? So the bailment of goods for a security for payment of a debt. Now, what is the security for the payment? It is your house, right? So the bailment of goods as security for payment of a debt or performance of a promise is called pledge. The bailer is in the case called the pawner. The bailee is called the pawnee, right? So in this case, the bailer is called the pawner and the bailee is called the pawnee. How bailment is different from pledge? Bailment can be of any purpose, but pledge can be for the purpose of security of the performance. So in case of the auto dealer example, it is for a purpose of getting auto repair and service done, right? It is not, we are not giving your bike as a security for something, for the performance of a specific. But when you pledge your property to get amount from the bank, then it means only for the security purpose you are pledging your property. So in this way, the bailment is different from that of pledge. So what are the rights of a pawnee? Right to retain goods. Yes, the pawnee has all rights to retain the goods. The pawnee is entitled to receive from the pawner extraordinary expenses for the preservation of goods pledged. Yes, if the pawner makes default in payment of the debt or performance at the stipulated time of the promise in respect of which the goods were pledged, the pawnee may bring a suit against the pawner upon the debt or promise. So pawner rights, so the relationship between pawner and pawnee is that such that when a pawner borrows some amount from the pawnee, let's say I, as a person, I am pledging my property to get 1,000,000 rupees from bank, right? So now the bank has all the rights to retain my property. Yes, until unless I discharge my debt, isn't it? Second, the pawnee is entitled to receive from the pawner extraordinary expenses incurred by him for the preservation of goods pledged. Just in case, let's say, to preserve my goods, the bank is incurring various extraordinary expenses, and he is entitled to receive it from me. If I make any default of the debt, if I don't pay back the money within the stipulated time, I have borrowed 1 lakh from bank, right? And I have to return it back within 5 years. If I don't do so, then the bank can file a suit against me for the debt or promise, right? So this is what pledge is all about. So we know what are the rights of a pawnee, and we know what is the difference between the bailment and the pledge. So quickly, could someone tell me what is the difference between bailment and pledge? Anyone? Anyone would like to explain me what is a pledge and what is bailment? You can put it in very simple words. Yes, sir. Harsha, anyone? Just explain me in simple words what you understood by the term bailment. Pledges against security for specific period. Absolutely, Srividya. But bail is not specifically for the security purpose, right? Exactly. So that's the difference between a pledge and the bailment. So let's talk about the. Now let us talk about the rights of a pawner. Right to redeem the goods or debts. When I say right to redeem the goods or debts, so like I said, I borrowed 1 lakh rupees from the bank, right? So once I repay back the amount to the bank has no right to hold my pledged property. So they have to return back. I have all the right to redeem my goods, right? Preservation and maintenance of the goods. Now that I have pledged my property to the bank, it doesn't mean that the bank should not preserve or maintain my good. I have all right to ask the bank to preserve and maintain my goods till I pay off my debts and retain my goods from the bank. So these are the rights of the pawner and also the rights of the pawnee. So next topic is contracts of agency. Okay, so Let's talk about the contract of agency. So you will have come across the agent, right? Agent is a very common word who acts on behalf of the actual owner. He acts on behalf of the principal for a commission or something, right? So he enters into a contract with a third party, right? So let's see how our Indian Contract Act defines agent. An agent is a person employed to do or any act for another to represent another in dealings with third person. So I want to sell books to a person who's in Kolkata, all right? And agent appointed in Kolkata who does transactions on behalf of me. But if I have authorized him to do so, the person from whom such act is done or who is represented is also called the principal. So when I appoint an agent in Kolkata to sell my goods to another person B, I am the principal and the person who's selling on my behalf is the agent, right? So the function of an agent is to bring his principal in contact with the third. He will bring in contact with the third person, but what he'll do is he'll carry out the duties on behalf of me because I'm not existent at that period of time or at that place, right? So I do my business through my agent. So he comes in contact with the third person. He will carry out the transactions on behalf of me for a commission for a paid commission from me. So here in this case, I'm the principal and he's the agent. So terms of agency depends upon the agreement between the principal and agent. So when I want to appoint an agent in Kolkata, so I will come up with my own terms and conditions which we both will agree upon, and there is an agreement between the principal, that is me, and the agent in Kolkata, right? So it is not necessary to have an agreement in writing. So according to Indian Contract Act, in English law, there is it has to be in writing, but according to Indian Contract Act, the agreement between the agent and the principal need not be in writing, it can also be oral. So as between principal and third party, any person can become an agent, right? So between me and the third party, the buyer, anyone can become an agent as per the contract entered into between the principal and the agent. No consideration is required to create agency, right? So intention of the parties, whether a person does intend to act on behalf of another person as agent is also important, right? So there should be intention on both parties, to the contract. The party have an intention to appoint to carry out transactions on behalf of me. At the same time, an agent should also have an intention to act on behalf of the principal, right? So that means both the intentions of the party should be mutual to carry out an principal agent relationship. So let us quickly look into examples which explains the relationship between a principal and agent. A and B are two real brothers. A lives in Delhi, whereas B lives in Kolkata. B has a flat in Delhi, which is let out by him. So A and B are brothers. A lives in Delhi and B lives in Kolkata. B has a flat in Delhi, which is let out by him, and A takes the rent and deposits in B account. This is a case of agency between A and B, though it is not in writing, right? So one person collects the rent and deposits on B's account on his behalf. So there is a kind of agency relationship which exists between A and B, right? So by ratification, the person acts on behalf of another without his consent, and the other person accepts his act. The acts are called said to be ratified. So let us take the main example, the same example. A and B are real brothers, right? So A is living in Delhi and B lives in Kolkata, right? So now B has a flat in Delhi and pays rent. B is not asking A to collect rent on his behalf. But what A does, okay, B is my brother who has a flat in Delhi. Let me collect on my brother's behalf, and he collects the amount without B telling him to collect, and he sends and he puts it in B's account. Now B comes to know that A has collected, but then he says, okay, fine, I am okay with you collecting rent on behalf of me. So you can collect rent on behalf of me and deposit in my account. Though initially the agency relationship was carried out by A without B's consent, eventually B agreed to whatever A did. So he has ratified A's act. as if it was authorized by him, right? So when he accepts whatever has been done by A, even without his consent, if he says that, yes, you have done this without my consent, but I'm still going to ratify your act, I'm authorizing you to do so, then it is said that the sale, the whatever transaction has happened, taking into account the principal and agent relationship is valid. So let us look into this example. A sold B's flat without B's authority and remitted the sum in B's bank account. Mr. A, without B's knowledge, he sold B's flat, and whatever amount he collected, let's say 20 lakh rupees, he has remitted in B's bank account. So B later on ratified his act. Maybe he felt that, okay, fine, he has sold my flat for a reasonable amount. Maybe I should accept whatever he has done. I don't want to sue him for the acts which he has done without my authority. I'm going to ratify his act. Then the sale made by B becomes valid. But if B does not ratify the act of his agent, then the sale is not valid because it was not authorized by B, right? So that's how it works, the principal and agent relationship. So there has to be two parties in the contract, and they should have a relationship of an agent and the principal, and the agent will carry out transactions or he will act as per the as authorized by the principal, right? He will carry out transactions on his behalf. Maybe it may or may not be for a compensation, but when he does so, the relationship of principal comes into existence. So when when it is done without principal's authority, and principal eventually ratifies such behavior of the agent, then the contract, the whatever transaction which has been entered into by agent becomes valid. But if he does not ratify the act which was done by the agent without his authority, then whatever the transaction entered into by the agent, it is not valid at all. Right? So let us see what are the essential requirements for a valid ratification. The principal must have contractual capacity both at the time of the said act as well as the time of the ratification. Right? He should have a contractual capacity. So he should have the capacity to enter into contract. So it may be at the time of the said act or at the time of the ratification. So he should have the contractual capacity. Let us take the same example of selling B's flat without his authority. He must have the contractual capacity when the transaction actually happened, and also when he ratified such transaction made by agent. The principal must be in existence at the time of contract. Yes, the principal must exist. If he is dead, or if he is dead, he is not in existence at the time of contract, then the contract cannot be ratified, right? So ratification must be done with the full knowledge of the facts. So when can he ratify? If in case if B wants to ratify the act done by A, the agent, then he should have the full knowledge of the transaction, to whom he sold, how much he sold, whether the agreement has been entered into between by his agent and the other person to whom the flat is sold. So all kind of facts, it has to be brought to the knowledge of Mr. B so as to ratify the transaction made by his agent without his authority. Ratification must be done within a reasonable time, right? So let's say B's agent A enters into, like the same example, A is a B's agent, right? Where he sells B's flat without his authority. He has sold in the year of 2011. Now B cannot say that we cannot ratify the act 2015, right? There is a huge gap of 4 to 5 years. So it is not a reasonable time to ratify this act, right? So it has to be done within a reasonable time. When it comes into his knowledge that such transaction has been carried out without his authorization, then he has to pitch in and tell that, yes, I'm going to ratify that, or no, I'm not ratifying your act which is done without my authorization. It has to be done within a reasonable frame of time. The act of ratification must be lawful and legal. So ratification can be done only if the transaction so performed is lawful and legal, and such ratification has to be lawful and legal, right? It should be bound. It should bind with all the rules of laws existing in that particular state, isn't it? So there can be ratification or rejection of whole transaction in total, but not in part. So let's say B has sold a house and also a piece of land which exists near the house, which also belongs to the principal. Now, principal cannot say that you have sold both the house and a piece of land without my authority. But what I will do is I will ratify your act of selling the house, but I will not ratify your act of selling the piece of land. So he cannot do it. Either he has to accept or ratify the whole transaction, or he has to reject the whole transaction. He cannot say that I will ratify part of the transaction, or I will reject part of the transaction. Either he has to do it in total, and it cannot be in part. Ratification should be third party into damage, right? So such ratification should put the party into damage. So that is also one of the essential requirement of a valid ratification. Then sub-agent. Who is a sub-agent? A person is employed by an agent is called a sub-agent, right? To carry out activities on his behalf. So let's see. So sub-agent is a person employed by and acting under the control of the business of agency, right? Original agent, like I said, a sub-agent is appointed by the agent himself. So let us see, we'll see the relationship between the principal and the person duly appointed by the agent. So you know the relationship between, how the relation between the principal and the agent exists. So what happens when the agent appoints a sub-agent? What is the relationship between the principal and the sub-agent now? So let us look into the illustration. First illustration, the solicitor to sell his estate by auction, right? The person who conducts auction now becomes the sub-agent. Now, in case of this his solicitor, it cannot be a sub-agent relationship. In case of an auctioneer, or when I say when A directs B, his solicitor, to sell his estate by auction, the auctioneer cannot be a sub-agent. We will see this is an example where we will say that the sub-agent relationship does not exist. We will further look into examples where the sub-agent relationship is highlighted. So here, to sell his estate by auction and to employ an auctioneer for the purpose, B names C an auctioneer to conduct the sale. C is not the sub-agent, but he is A's agent for the conduct of a sale, right? So this auctioneer directly becomes the sub-agent, becomes the agent for the auctioneer directly becomes the agent for A, right? So the auctioneer cannot be called as the sub-agent for Mr. B. So what is the term? Let's talk about the termination of agency, when the agency contracts come into an end. So by act of party, so there is an agreement between principal and agent, right? If the agency relation, if I enter into a agreement with my agent saying that our term of agency will be there for 2 years. So what happens? The contract will come to an end after 2 years, or I will say that I will appoint you as an agent only for this particular transaction. So as per my agreement between the agent and me, the principal, once the transaction is complete, I will put the agency relationship will automatically come to an end. So by act of the parties. So revocation by the principal. So the authority of the agent anytime before the authority has been exercised. So let's say that I have appointed an agent in Kolkata to sell my goods to a customer in Kolkata, and I come to know that this particular agent whom I have appointed, he is not a sound person, or he has committed some fraud on this my agent. So what I do, I immediately revoke the authority of the agent anytime before the authority has been exercised. Then automatically the agency relationship will be terminated, right? So let us look into these examples as well to understand how the agency relationship is terminated. A authorizes B to buy 1,000 bales of cotton on account of A. And to pay for it out of A's money remaining in B's hand. So B has some amount of A in his hand, and I'm authorizing Mr. B, go buy 1,000 bales of cotton and pay, and you have the money, right? And, my money with you, so you pay out of it. Now, Mr. B also buy 1,000 bales of cotton so as to make him personally liable for the price. A cannot revoke B's authority so far as the regards of the payment for the cotton. So when I what exactly is the, how can I revoke by, how a revocation can be made by the principal? I have to revoke the authority of the agent even before he exercises authority, right? So in this example, had the B had not gone and bought 1,000 bales of cotton, if I want to revoke the authority of the agent, I have to do so even before he goes and buys 1,000 bales of cotton. But if he buys 1,000 bales of cotton, after that point of time, I cannot revoke his authority. So in this example, it's quite clear that when a principal wants an agent to perform an activity on his behalf, he has a right to revoke his authority only before the performance of such act by the agent. But if he performs the act, he has no rights to revoke the authority of the agent, right? So let us look into the next example. A authorizes B to buy 1,000 bales of cotton on account of A and to pay for it out of A's money remaining in B's hands. B buys cotton in A's name and so not to render himself personally liable for the price. A can revoke B's authority to pay for the cotton. So what happened in the first example? He took personal liability for the 100 bales of cotton, 1,000 bales of cotton, right? Here what happens, he does not take the personal liability. If you look at the first example, there is a clause so as to make him personally liable for the price, right? Because he has taken his own name. But here, when he does not take his own name, but he takes on behalf of A and he buys cotton in on A's name, then A can revoke B's authority to pay for the cotton, right? So it is quite clear that first thing is that if A wants to pay his authority on engagement, it has to happen before the performance of such performance of any act by the agent. At the same time, when agent has acted on behalf of the principal, then it means he can revoke B's authority to pay. But if the agent has acted on his behalf, he has taken the personal liability of the price, he has sold something on his own name, then it cannot revoke B's authority so far as regards of the payment of the goods. Right? Did you understand the revocation by the principal clearly?
Yes, ma'am.
Yeah, great. So let us move on to the next topic. So next is how the revocation happens by operation of law. So once the performance of contract, when I say performance of the contract, so once the contract, whatever the contract has been entered into has been performed, then it is revoked, right? Expiry of period for which the agent is appointed, even if the work is incomplete. So I appoint an agent to sell goods to Mr. B in Kolkata, but I have appointed that agent only for a period of 1 month. When the 1 month has expired and my agent has still not sold the goods to Mr. B, who is in Kolkata. So though it stands incomplete, the expiry of the term, right? The expiry of the contract happens within a month. So he automatically becomes terminated. Death or insanity of principal or agent, yes. If the principal dies or the agent dies, the contract will come to an end. Insolvency of principal or agent. If I'm not in a position to, if I have an agent and that agent is also insolvent, he is not able to take care of the expenses which he is supposed to incur, and he is insolvent, he has no money, or me as a principal, I have no money to buy goods from a particular agent in Kolkata, I am insolvent, then the contract will automatically come to an end. Destruction of subject matter. So I have 100 bales of cotton which I want to sell to a person in Kolkata, and my cotton factory, the place where I have stored my cotton, everything is damaged because of fire. So the subject matter of the contract, which is cotton, it itself is not in existence. So The destruction of subject matter will automatically lead to termination of the contract, isn't it? So a dissolution of the company, whether it is principal or agent. So there is an agency, the agency company becomes dissolved, or my company becomes dissolved. I cannot carry out the contract, right? Contract of agency. So the countries of principal and agents break into a war. So I am the principal. I have an agent in Pakistan, and we in both the countries enter into a war. Then the termination there will be a termination of the contract. Sub-agents authority is terminated on termination of authority of the agent. So the authority itself is terminated. Automatically, the sub-agent who is appointed by the agent has to come to an end, right? So when I terminate the agency relationship, automatically the sub-agency relationship will also be authority or the relationship will also be terminated. So let's quickly look into these illustrations. A directs B to sell goods for him and agrees to give B 5% commission on the price fixed by the goods. Right? A afterwards by letter revokes B's authority. B after the letter is sent but before he receives it, sells the goods for 100 rupees. The sale is binding on A and B is entitled to 5 rupees on his commission. So clearly look at the example. A says B, you sell goods on her and I'll pay you 55% commission on the price fetched by sale of goods. A afterwards by letter revokes B authority. B after the letter is sent, but before he receives it. So what happens is A sends a letter, but even before he receives the letter, he sells the goods for 100 rupees, right? So since the sale was made even before receiving the letter of revocation by the principal, agent, what he does, he carries out the transaction. He sells the goods for 100 rupees. The sale is binding on A. The sale is binding on A, and B has to get 5 rupees on his commission. But if at all he carries out the sale after he receives a letter, the sale is not binding on A and he is not eligible for the commission amount which principal has promised him, right? Similarly, A directs B, his agent, to pay certain sum of money to C. A dies and D takes out probate to his will. B, after A's death, before hearing of it, pays the money to C. The payment is good against D, the executor, isn't it? So even though it is after A's death, but he has not heard of A's death yet. Even before that, he pays the money. Had he heard about A's death, then it would have been a different scenario. But even he has not heard of A's death, and he makes payment because he was unaware of the situation. So the payment is good against the executor, right? So we'll talk about the rights of an agent. What are the rights of an agent? Agents lien on principal's property. In the absence of a contrary, an agent is entitled to retain goods, papers, and other property, whether movable or immovable, of a principal received by him until the amount due himself for commission, disbursements, or services has been paid or accounted for him, isn't it? So when you enter into an agency relationship, when agent carries out business on behalf of you or carries out transactions on behalf of you, he is entitled to some amount of commission or brokerage, isn't it? So if you have given your goods to A, let's say you have given 100 bales to Mr. A, who is your agent, he sells 50% of 50 bales of cotton to Mr. C. The rest of the 50 bales of cotton is lying with him, right? So only when you pay the commission of he's saying that I'll retain your goods because you have not paid the commission yet. So he has all right to retain your goods until unless you pay the commission which is due to him. So he has agent's lien on, this is called agent's lien on principal property. The lien is nothing but right to take possession of someone's goods. Right to receive remuneration as per the agreement, or if there is no agreement, reasonable remuneration, isn't it? So an agency relationship comes into existence only on an agreement of certain amount of remuneration. If remuneration is not there, a reasonable remuneration has to be agreed upon by the agent and the principal. So let us look into this example. A employs B to recover 1,000 from C. Though B's misconduct, the money is not entitled to no remuneration for his services unless he make with the loss, right? So what happens is he has employed B to recover 1,000 from C. Through B's misconduct, the money is not recovered. So B is the agent here and A is the principal. So B has not acted in a proper manner, so the money was not recovered. B is entitled to no remuneration for her services and must make the good loss, right? So let us say I employ a person in Kolkata to sell my goods to Mr. C. Now B has sold goods to C. But C is a good friend of my agent. He did not pay money, and because of the misconduct of my agent, I have not got my money back. And now B say, my agent saying that I have sold your goods, so you have to pay my commission, though you have not received the money for the goods sold. I will say that no, you have not acted in a proper manner. I have not received the money for my goods which you have sold because of your misconduct. At the same time, you have to claim. You are gonna make the make good the loss. You are going to pay me out of your pocket for whatever loss I have incurred. At the same time, not gonna pay you any remuneration, because why you have not acted in a good manner. It is because of your misconduct. I have come across so much of loss, and you have to make it good. And I will also not pay you the remuneration for services. Right. So next, the agent has the right to be indemnified against all lawful acts done by him in exercise of authority conferred upon him. So he has the right to be indemnified if something against all lawful acts done by him in exercise of authority. So he has the right to be indemnified in the sense if I'm given an agent an authority and he has acted in a lawful manner, for he has to be indemnified against, he has to be protected against all lawful acts done by him in exercise of authority, right? Authority which I as a principal has given the agent, right? So the agent has a right to be compensated for all injuries sustained by him because of negligence or lack of skill on part of principal. So I do not disclose any fact pertaining to my goods because of the silence on my part. My agent has incurred some kind of loss. It is because of my negligence or lack of skill or lack of management skill on my part. The agent has incurred some kind of loss. So he has all rights to be compensated for all the injuries sustained by him because of me. Right? So these are the rights of an agent when it comes to a principal-agent relationship. So are you clear with the agency relationship here? Anyone has got doubts with that? Srividya, it is not clear. How about the voice now? It is fine. Are you able to hear me? Okay, fine, right. So whenever it is not clear, I would prefer you to say it, right? So you can tell me whenever it is not clear. I can stop or repeat whatever I have said. Okay, great, Akbar. So let us see who's a pretend agent. Like the name suggests, an agent who pretends to be an agent, right? So a person who is not authorized agent of another but pretends himself to be the authorized agent of another and thereby induces a third party to deal with him as such agent is called a pretended agent, right? So I do not say a person in Kolkata to can transactions on my behalf, but he carries out transactions on my behalf without me authorizing him as an agent. And what he does, he says that I'm an agent of Mrs. Purnima, who stays in Bangalore, and I'm going to, and she wants to enter into a deal with you. So I'll sell these goods, you have to pay me back. So he induces a third party to deal with him as such an agent of the principal, right? So he pretends to be an agent, though I have not authorized him as an agent. So what is the liability of the pretended agent? So it is dealt in the section 235. A person untruly representing the authorized agent of another and thereby inducing a third person to deal with him as such agent is liable if his alleged employer does not ratify his acts to make compensation to the other. So it is quite obvious, right? If a person is pretending to be an agent and he, even without me, the principal authorizing him, he enters into any kind of transactions for any damages which he incurred, he is liable for such damages. But there is a clause here: if I ratify his act, you remember the ratification act example, right? A is a brother of B. B, what he does, he sells B's house on his behalf without his authority, and later on B ratifies his act, saying that okay, fine, you have sold it for a reasonable price, so I'm okay with your act. So when he's accepting his act, which is done without his authority, he's ratifying his act. If he does so, then he is not, the pretend agent is not liable for any damage. But the pretend agent says, it pretends to be an agent of a principal and works out a deal with another third party. So whatever damages he has caused, he is liable for it if such act is not ratified by the principal, right? So let us look into this example. The author dealer of XYA Associates. Even though this is not the anyway, he's not in any way connected with XYA Associates, and thus induces him to sell goods worth 500 to them on credit. So he is misusing the name of XYA Associates, and he enters into a transaction inducing the third party to sell goods worth 500 to him on credit. So and now the company does not ratify their ad of the X, denying them as a agent. So neither X nor Y have any claim to proceed against XY Associates. So someone says that I am on behalf of this person, I am going to enter into a deal with you, but actually this person is not authorized by the principal. Can the principal be held liable for all the damages which the other party has? The other party has incurred? Definitely not, right? Because I'm not aware that the person has actually claimed himself as an agent of me, and he enters into a contract. So let's say I'm the principal, Mr. B in Kolkata enters into a contract on my behalf with Mr. C, and he buys goods from me. Now C says that Mr. B tells me that Mr. B told me that he is your agent, and I want to claim the damages because I have sent my goods and I have not got back my money. Can he hold me responsible? Am I liable for the damages caused by the agent, the pretending agent? Definitely not. Right? Or they cannot sue me for the damages caused by the pretended agent to Mr. C, right? So next topic is effect on misrepresentation or fraud by agent. So let us look into this example. A being B's agent for the sale of goods induces C to buy them by a misrepresentation which he was not authorized by B to make. So A being B's agent for the sale of goods, he induces C to buy them by a misrepresentation, and he was not authorized to do so by B. So for example, I'm going to sell 100 bales of cotton in Kolkata to my agent Mr. B. Now Mr. B, what he does that he makes a misrepresentation. When I say misrepresentation, he thinks the fact to be true, but it is actually not true. It is the goods which I am going to sell to the ultimate customer is of second quality, but he makes a misrepresentation that the cotton which I'm selling on behalf of my principal is of first quality. So there is a misrepresentation which is made by my agent, but he was not authorized to do so by me, right? So the contract is voidable as between B and C at the option of C, right? So C being the ultimate customer, it is voidable at the option of C, correct? So next, A, the captain of B's ship signs bill of lading without having received on board the goods mentioned. So without receiving the goods, he is not supposed to sign the bills of lading, right? So the bill of lading or what has been within the consignment. So this is the effect of any kind of agreement on misrepresentation and fraudulent practice by an agent. So what is an irrevocable agency? An agency which cannot be terminated or put to an end is called irrevocable. The term irrevocable is nothing but you cannot revoke. It is not reversible, right? So what is an agency cannot be terminated or put to an end? That is such kind of agency relationship is called irrevocable agency. So let us look into this example. A is indebted to B. He appoints him as his agent and thus authorizes him to sell his land and to pay himself in discharge of his debt. He cannot revoke the authority nor put an end to the authority, isn't it? Why? See, what happens is A is indebted to B. Let's say A has he has borrowed 1 lakh rupees from B. Right now, A tells B that I owe you 1 lakh rupees. So what I will do, I will appoint you as my agent. I'll authorize you to sell my land, and you can sell the land. You can act as my agent, sell the land. So whatever amount you get, I will use it to discharge your debt. Right. So he is bound to make him an agent and make him sell on his behalf and and make himself in discharge of his debt, isn't it? Now, can he revoke the authority? Definitely not. He cannot put an end to the authority. In a way, he has to repay back his amount, right? He can do so only by selling his land, and he appoints B, the creditor itself, as an agent. So he cannot revoke the authority or put an end to the authority. So in this case, the irrevocable agency comes into picture, right? So the second example, A consigns 100 kg of cherry to B, who has already made an advance to him on such consignment. So he has already made an advance and now desires B to sell the cherry and to repay himself out of the price. The amount of his advance. A cannot revoke the authority nor terminate the same. Why? Right? So A has consigns 100 kg of cherry to B. He has already made an advance to him on such consignment and now desires B to sell the cherry and repay him out of the price, the amount of his own advance, right? He wants to sell and repay himself out of the price. So A cannot revoke the authority and not terminate the same. This works as the first example, correct? So where the agent has incurred personal liability. Like I said, in first example, he is indebted to B, right? There is a personal liability here. I borrowed money from Mr. B, then I'm personally liable to repay it back. So where the agent has incurred personal liability, then where the agent has exercised a part of his authority, as has already done. So where the agent has already exercised a part of his authority, when he has fulfilled the part of his authority, then obviously the agency is not irrevocable, right? So the concept of this is the concept of irrevocable agency. So are you clear with the concepts when it comes to contract of agency?
Yes, ma'am.
Okay.
Actually, I have one clarification.
I'm sorry?
I have one clarification. If they are asking the question like that, termination of payment, what is the termination of payment? We can give our own example. No issue, no?
Akbar, your voice is breaking. Do you mind? Akbar, I'm really sorry, your voice is breaking. Do you mind typing it? Akbar, can you please type your question? Okay. You can ask the termination of payment. No, you cannot do that. They will see. They won't ask you any direct question as such. They will ask you, what is the terminal? How the termination of payment takes place. If they ask, they rarely ask such direct question. If they ask you, so you can put down in points. If they ask you directly, then you can give your own example to actually justify your answer. But most of the case, it won't be like that. They will probably give you a case related to bailment. You'll be in a position to justify the case, right? So, like I said in my previous class, you can give examples of most important case laws for which the court has already provided judgment, if you know any. If not, I would suggest you to go through the case laws which you're going to answer. If it is related to bailment, you have to put down in points as to why you are going to, or how you're going to justify it. So when there is already a case law, I won't prefer you to give the examples like A and B. But if it is a direct question where they ask you, they'll give any situation and justify the case law. As far as bailment is concerned, of course, Pavani, you can write down in your own words, because most of the time what happens is they won't ask the same case laws as such. So in the best case, I would suggest you to remember the section if possible, because there will be so many sections. It will be easy for you if you're going through one particular wherever the famous okay, fine, let me answer the question one by one. Okay, fine. First, Pavani, you asked we can use and write in your own words. Yes, you can definitely write and use it in your own words, because most of the time the practical questions which they are asking will be different. So all you have to do is understand the concept, use the keywords. When I say bailment, you know who's a bailer, and use such keywords so that you will present your questions in a correct way. I would suggest you to remember this section. All you can do is just go through Indian Contract Act and just put all these sections in one paper and see, okay, this section Taylor and Bailey, and it is this section. So in that way, when you go through every chapter, you just jot down these sections and what it relates to, so that it will be easy for you to remember, right? Then Akbar, you are okay. Of course, see, whatever major cases which are being dealt with, for example, initially I started with Balfour and Balfour versus Balfour cases, right? So those are prominent cases which were even given in your book, actually. So such prominent cases, yes, I will definitely, when I go through all such rules and provisions of any particular act, if there are any prominent cases, I'm definitely discussing with you people. But I also pick on a few small examples like A and B, so that to make your understanding better. So what I've already highlighted few important cases in the study notes. So what I will do is that I will probably highlight such important cases which you may be able to quote even during your examination, right? Then okay, great. So do you have any further question? Yeah, Shrikant, you were asking me about this question in 2012, right? Whether it silence amounts to fraud. Of course, silence does not amount to fraud. So if you remember, I did, I gave you 3-4 illustrations when I took the fraud topic. So let me just share with you those examples again. So normally silence, A is going to sell his goods to B. So in normal scenario, if he is silent about any facts about the goods, let's say the goods are of low quality, if he is very silent, if he is silent about the fact that the goods are of low quality, it does not amount to fraud. But also let us also quickly look into a few cases where fraud amounts to silence, where silence amounts to fraud, and where silence does not amount to fraud. So Srividya, in this case, where there is a direct question like this, for example, whether silence amount of fraud, I would suggest you to explain it with illustrations. So I have just taken out from my own notes itself so that it will be easy for you to understand, right? So Mia, can you see this?
Ma'am, I understood.
Are you able to view? You are able to view the? Sorry.
Ma'am, I understood the silence is not fraud, but exceptions I didn't understand.
Okay. What do you didn't understand?
Exceptions, ma'am.
Exceptions you didn't understand. Okay, okay. So let me just put it. I'll just explain to you one more time. Let me know if you understood it, right? Give me a minute, Srividya. All right, okay. So here, first illustration. A says by option to B a horse which A knows to be unsound. A says nothing about B, about how horse unsound. So Srividya, let's say you're selling a horse to Mr. B, okay, and you know that the horse is not unsound, and you keep silent about the fact that the horse is not sound. Then you whatever you do is not amounting to fraud, because a person who's going to buy from you a horse has the right and duty to ask you whether whatever you see. When you go to a shop, when you want to buy an electronic good, it is you who ask them, right? Does it have a warranty period? Does it work? If you're buying a car, you will ask, does it run by petrol or diesel? But if he keeps quiet about if it is petrol driven or diesel driven, you're not going to tell them that you have committed fraud. I wanted a petrol driven vehicle, but you gave me a diesel driven vehicle. You will not say that, right? So you as a customer, you have to exercise the better due diligence to understand the product which you're buying. So in this case, when A sells by auction to B a horse which A knows to be unsound and he does not disclose the fact, then this is not a fraud in case of A. Right? Second exception B says to A, if you do not deny it, I shall assume that the horse is sound. So here what happens then, what happens is you go to a car dealer and you tell him, if you're silent about it, I will assume that the car which you are giving me is petrol driven. But now if now that you said so, the sales representative have to tell you that no ma'am, I cannot be silent about the fact because this is diesel driven. But if he keeps quiet, then that time the silence is equivalent to speech. Okay. So now the third definition, A and B being traders enter upon a contract. A has private information of a change in prices which would affect B's willingness to proceed with the contract. A is not bound to inform him, right? So in this case, even in the third case, it is similar as first case. This will not amount to fraud, right? So mere silence as to facts or the willingness of facts to affect the willingness of a person to enter into a contract is not a fraud. So did you understand, Srividya? Srividya, are you clear with the
Understood, ma'am, but the question is asked by Pavani.
question is asked by Pavan? No, I didn't get it.
Question is asked by Pavani, ma'am.
Okay, fine. Great. So I believe everyone understood the concept of whether mere silence amounts to fraud or not, right?
Yes, ma'am.
Yes, ma'am.
Okay, perfect. Fine. So by this we'll come to today's this is the end of the session. So tomorrow we'll look into Sale of Goods Act, and we'll also look into another. I think we have already gone through ethics and corporate governance, right? So we will also look into a new chapter tomorrow. Okay. So have a great evening. Thank you so much.
Thank
you, ma'am.
Good night, ma'am.
Good night, ma'am.
Good night. Good night. Bye bye.